Hello, welcome. This is the weekly review, making sense of relevant topics and news. It is a program of Sawasawa Network. My name is Roger Alfred Yoromodi. I'm the producer and the host. Today, I'm joined by Advocate Tong Kuocnin. He is a lawyer, constitutional lawyer, specialist and advocate at the Nile Advocates and Associates. And also Bryan Itorong, managing partner, Oboy and co-advocates. We shall be looking into President Kiir's recent Republican decrees for the Reconstitution and appointment of state advisors, state ministers, members of state independent commissions and county commissioners, and their validity, since so far we have several opinions from several lawyers varying from one another, some saying the orders, the decrees were in line with the Constitution and the agreement, and while others are saying they are contrary to the agreement and the Constitution. Welcome to the weekly review, the two of you, the lawyers.
Thank you.
Well, let me start with you, Tong, Court, being a constitutional law specialist. You see, the president made a lot of citations when he was issuing the decree. He started with mentioning articles 1068, 2A of the Transitional Constitution of the Republic of South Sudan, amended, read together with articles 1.921 and articles 1.162 and 1.163 and annexed D of the implementation matrix, numbers 20 and 21 of the revitalized agreement 2018. What is your opinion about the decrees actually for those?
Is that question to me,
yes.
Alfred?
Yes, Tong. Yes, your opinion with regards to the decrees. Are you on the side of those who say they're in line with the agreement, or those who say that this is a violation of the agreement and the transitional constitution is amended?
All right. Okay. Thank you for having me on this forum. First of all, you know, our number one problem is that we always read the Constitution upside down. Okay, you get my point. What do I mean by reading the Constitution upside down? You cannot tell me, okay, that the agreement concluded between two individuals or between parties overrides the will of the people. Okay, if you look at the text of the Constitution, it tells you that you know the powers and everything that is done by the government is derived from the will of the people. Okay. So I cannot agree with those who make the connotations that this is a violation of the agreement. You know, even this idea that the provisions of the terms of the agreement prevails over the Constitution, I don't quite agree with that. Okay, because if you look at the way the agreements are concluded, it's not actually the way the constitutions are promulgated. Okay. The Constitution is a wider document, okay, written, okay, discussed and deliberated by the people, not by the parties to the conflict, okay. Now, the challenge here is that why does the parties to the conflict always want, okay, the terms of the agreement to prevail over the Constitution? This is not, you know, a constitutional matter. This is more of a political matter than law. Okay, so I beg to disagree with those who have the view that you know there is a violation of the agreement over the Constitution, and you know, in fact, there is a violation of the Constitution rather than an agreement.
Well. Before I bring in Advocate Oboy Itorong, the agreement has been incorporated into the Constitution, and the terms you're talking about that the agreement prevails over the Constitution actually is part now of the Constitution, and it recognizes that the agreement takes precedence over the Constitution and other laws. So since it has become part of the law, part of the Constitution, What are you saying that is different here? Because it's already part of the constitution.
Okay, well, if you look at the arguments of the people who are opposing the way the president, okay, has appointed the state government, and those who are proposing the way the president has issued his decree appointing the governors, the advisors, the ministers, the deputy governors, and all these commissions, okay, people are still maintaining the simple fact that the agreements is still, okay, prevailing over the constitution, even when the agreement itself has been incorporated into the constitution. Now, which other terms of the agreement that are you talking again that should prevail over the constitution if the agreement has equally been incorporated into the into the constitution? It is the text of the constitution now that should prevail over any other pieces of legislation in the country, because the constitution now is the fundamental law of the country, is the supreme law, and any law that contradicts any provision of the constitution must be null and void as to the inconsistency. Do you see this point? Now, the argument is very weird and is awkward. Awkward in the sense that people who are not well versed in the law, okay, but more or less of a political activist, are the one driving this hawk. Okay, they are still maintaining this simple, illusion that the agreement, prevails over the constitution, forgetting the fact that once it has been incorporated into the constitution, there's no point you can still be talking about any terms of the agreement is still prevailing over the provisions of the constitution. It is the constitution now that overrides any piece of legislation that is enforced in the country, because it is the fundamental law. It is already the supreme law.
Yet the president is quoting the agreement himself. He's quoting the agreement in his decrees. So you see the point. If you say the agreement now is part of the constitution, it should not be quoted anymore, then you also need to look into the decree.
That is ridiculous.
The president has been quoting the agreement.
That is ridiculous.
But we'll get back to that point. Let's welcome Bryan. Bryan, what's your take on this issue? Of course, many lawyers have already expressed themselves. Where do you stand?
Thank you so much, Roger, for having me on this program. Well, just to begin with, I agree with my colleague, Advocate Tong, that the Constitution derives from the will of the people, and that the Constitution is the supreme law of the land, and that no any other laws or agreements, for that matter, should override the Constitution. Now, having looked at that, if you look at the provision of the agreement, the revitalized agreement, there is that provision that says that the terms of the agreement shall prevail over the transitional constitution. Of course, I do not agree with that. It is a political issue that the parties felt that it was necessary to come up with that provision. However, the agreement specifically provides for its incorporation into the transitional constitution of the Republic of South Sudan. And indeed, that is what has been done. The access has already been incorporated into our transitional constitution, ratified or approved by our National Legislative Assembly and assented to by the President. That means that access has actually already been incorporated, and therefore it is part and parcel of our constitution. So there is no need to continue talking about the provisions of access being inconsistent, for instance, with our constitution. Now, in regards to the decrees themselves, if you look at the decrees, first of all, the decrees were based on certain provisions. One, Article 106, A, 2A of the Constitution. Two, Article 1.921. Looking at those provisions, Article 106A provides for the powers of the president in consultation with the past vice president and the vice president to appoint constitutional office holders and judicial officers, including the governors. Now, the article that was quoted as well in that decree, of which is the access, is actually a reiteration. It is actually the same as what Article 106 of the Constitution is saying as amended, that the president has the powers to appoint constitutional state office holders as well as the governors. Having said that, the issue, you see, if you're trying to look at whether or not those decrees were legal or constitutional, you have to look at them separately. The powers of the president, for instance, to appoint the independent commission chairpersons and their deputies and the members, as well as the advisors of state governments, and the powers of the president to appoint the state ministers or ministers for that matter. Now, if I'm to look at the decree itself, the way it is, Article, of course, I've already stated Article 106, which gives the president the power to appoint constitutional state holders, office holders. The issue is whether those ministers, those deputy ministers, the advisors, country commissioners are constitutional office holders. Now, who are constitutional office holders? We should first answer that question. And if you look at the definition of constitutional office holders, according to the Black's Law Dictionary, is that these are people or government officials whose office has actually been established by the Constitution, and their mandate is specifically provided in the Constitution, and their terms of office are actually fixed. The question is, are the ministers, advisors, county commissioners, members of the independent state additional? Most of them are. Okay, you may talk of ministers, advisors, county commissioners. It is clear that they are not constitutional post holders because their offices are not created under the Constitution. Their functions, their responsibilities are not specified in the law. Also, their terms of office are not fixed. They can be fired anytime. So they are not actually constitutional state office holders. With regard to independent commissions, yes, you may say they are constitutional office holders. But in this case, we're dealing with state independent commissions. I don't think that the law actually provides for that, because if you look at the Constitution, it provides for the establishment of independent commissions, anti-corruption, human rights commission, and all. Under Part 9 of the Constitution, it lists all those independent commissions that are provided under the law, which is at the national level. But the Constitution does not provide for establishment of state independent commissions. I would try and ask what would be the function of a state independent commission, for instance, because if you look at the law, you look at the Constitution, you look at some of the enabling laws that provide for the establishment of these state commissions. For instance, Human Rights Commission. It says that although the head office is going to be in Juba, they have the mandate to establish state offices. So if Human Rights Commission, for instance, has the mandate to establish human rights state office in Tori, for instance, then what would be the need to actually establish a state independent commission? And if you look at access itself, or let me look at the provision. According to provision 119.1 of access, it states that it provides that at the beginning of the transitional period, there shall be a reconstitution of commissions at the national level only. It does not provide for reconstitution of independent commissions at state level. It only says at national level. So by that provision alone, the president has no authority to appoint commissioners, chairpersons and deputies at the state level. Having looked at that, let's go to the question of the ministers and advisors and their deputies. Now, if you look at the Constitution itself, if you look at Article 165(2), which was amended through amendment of 2020, that is the one that was incorporating acts into the Constitution, it says that the governor is the head of the executive organ in the state, and he has the powers to appoint and relieve the deputy governors, the advisors, and the ministers. That is a provision of the Constitution saying that. So if you look at, I wonder why that provision was actually ignored in the decree, because the decree was reading another provision while ignoring another one. And that is against actually rules of interpretation of Constitution. According to the rules, a Constitution is supposed to be interpreted as a whole. You don't look at one particular provision and then you ignore others. So I wonder why they actually ignored that. So that article is very clear. And by just looking at it, it is the mandate of the governor to appoint, and not the president.
Let's bring in
yes.
Tong. Council Tong, are you with us? Council Tong. Council Tong is I don't know what happened. Maybe internet, but we keep on waiting for him, and we'll get his perspective. You see, the issue of conflict you were mentioning also is rising from 165, Sabbatical 6 of the Transitional Constitution as amended, which says that the governor of each state shall be the head of the executive organ in the state and shall appoint and relieve deputy governor, state ministers, and in consultation with the president. Now the challenge is the appointment came through the president, and that provision remains in the Constitution. This is the conflict. There are possibly several effects that will come out of it, and from a perspective, what do you say, given that that provision exists and the president formed those ministers, appointed those ministers?
Well, I do not understand, for instance, the reason why the advisors of the president or whoever advises him went ahead and said that the president should actually appoint those government officials. If you look at this itself, and even our constitution the way it is, the spirit is actually, the spirit actually of access is to devolve more powers to the state. By the president appointing those state government officials, it means that he's actually usurping the powers of the governors himself, and that is against the provision of the Constitution. It is also against the spirit and letter of access. I don't understand why the president actually went ahead and appointed those individuals, those state government officials, because the law is very clear.
In terms
the
of
transitional constitution talks about it.
you differed on the commissions earlier, but you are not referring to the ministers. Tong, what would you say with regards to the ministers appointed by the president? The ministers, even the deputy governor, and also he cited the constitution, yet Article 165 of the constitution, Article 6, which says the governor of each state shall be the head of the executive organ in the state and shall appoint and relieve the deputy governor, advisors, and state ministers in consultation with the president, consultation and agreement of the president and vice president, vice president. That one is an explicit provision. Councillor Tong, what do you say about the diversion and the appointment of the ministers by the president?
My colleague Council Bryan made a very valid point. You know, if you look back when I started, I said our challenge is that we always read the Constitution upside down. Okay, look at what thing we have done now. After the president having issued presidential orders or decrees appointing the state, deputy governors.
Hello, seem to have lost Council Tong. The internet is kind of problematic for him, but let's continue until he comes. We have the issue of the states, for example, legislatures, which is supposed to run concurrently with that of the Transitional National Legislative Assembly, the national legislature, actually, the Transitional National Legislature. And one of the arguments made by the Minister of Information and spokesperson of the government is that the president is appointing those state officials because the constitution of the states have not incorporated the agreement into the state constitutions. Yet we know very well that state constitutions are limited by the national constitution. Once an agreement, for example, or terms of the constitution are changed, the states are supposed to adhere automatically to the national constitution. What would be your response if you were to respond to the minister? Because that is his argument, that the president is appointing those state officials because there is no revised constitutions in the state that have incorporated the agreement.
Well, I tend to really disagree with what Honorable Markway said, because our constitution is very clear. It is the governors to appoint, and the fact that there may not be state constitution for that matter, it does not. I don't believe that there's a lacuna itself until state constitutions are amended. I think the previous law continues to operate, and in those laws, still, it was the governors who have the authority to appoint ministers, their advisors. And that is what the Constitution is saying. That is what Access is saying. So I don't think that argument by Honorable Markway is actually a valid one. Is he trying to say that there's a lacuna, they are not in the state?
Welcome, Council Tong. You're back.
Come again?
Yes.
My internet is disturbing a lot. I was trying to make a point. Mm-hmm. What they did is the same mistake they did in 2015. Okay, when they created the 28 states, they canceled the 10 states, and then they created the 28 states before amending the constitution. This is what happened here. Now the president realized with his team that you know, there is a constitutional implication that there occasions here, you know, when he move ahead, you know, and deprive the governor of every state who is tasked by law, the constitution for that matter, to appoint, you know, the deputy governors, the advisors, the ministers, the head of commissions, you know, the commissioners, and, you know, members of the commission and all these other officials. Now, afterward, he issued another order giving powers, okay, to the governors to go and...
Right.
Hello? We've lost you again. Oh, you're with us. Council Tong? Council Tong, I can... Oh, you've lost him again. And he was making a point about the 28 and 32 states, which actually, if we remember very well, the decrease, for example, Order 36 of Republican Order 36, 2015, also did some changes on the issue of the state constitutions, because it gave the new states the powers to enact constitutions using their appointed legislatures. Now with the reversion, the reverting to 10 states, and I would not like to assume here, because there was a Constitutional Amendment Act 2020, Act number 7, which, according to the Office of the President last time, it gave the effect, had the legal effect of returning the country back to 10 states. And we talk about, for example, redress, because there are mechanisms established. For example, for those who would like to complain with regards to the deviation or violation of the agreement, you have the Peace Monitoring Body, RGMAT, and all those mechanisms. And the fact that the agreement also has been incorporated entirely, recognizing those issues. But when it comes to the conflicts, for example, because some of the incorporations were not done correctly, as required, and that is why sometimes people complain with regard to deviation from the agreement as opposed to what has been incorporated into the Constitution. What would be your advice to those who, for example, at the moment, insist they have legitimate cause that the agreement has been violated?
Is your question relating to individual citizens or the parties themselves?
Well, we've seen generally the many people who complain that the agreement has been violated. Some are members of the civil society, some are public figures, and many others. So with regards to what should they be doing, for example?
See, it is very tricky, because the agreement as it is, and before it was incorporated into the transitional constitution, or for instance, even those provisions that have not been incorporated in their letter, it's very difficult, because the agreement itself was a political, it was a political decision. And that's why you see that some people are complaining, saying that the agreement should never have been put to prevail over the Constitution, because the Constitution derives from the will of the people. It is the supreme law of the land everywhere in the world. You cannot bring an agreement between parties to override the Constitution.
It happens before in many places, and even when we were in Sudan, when the CPA got incorporated into the national constitution, prevailing over the terms of the constitution. And this happening, mechanisms that are outside the constitution that are done to resolve conflict, for example. And since it has happened already and the agreement got incorporated, we're looking, welcome back, Council Tong. We're looking at your recommendations, telling the people who are complaining that there is a violation of the agreement. There's a violation of the agreement, and or there is a violation also of the constitution which has already incorporated the agreement. With regards to what measures they should be taking, legal measures, other redress, what should they be doing if they have legitimate causes? Council Tong, welcome.
The agreement has been, yeah. First of all, the agreement has been incorporated into the constitution. There is only one document that people should be talking about. That is the constitution. The terms of the agreement itself as a whole has been incorporated into the constitution. So there's no any reason again that people should continue talking about violations of the agreement. Which violation of the agreement? Which agreement are they talking? Is it the same agreement that has been incorporated into the constitution and therefore it has become part of our fundamental law, or which one again? Okay, the moment that the agreement has been incorporated in the constitution is the same moment that it ceases, okay, to have any operative. Are you listening?
Yes, I'm getting you. I'm getting you.
Okay. Yes, people should stop. Talking about violations of the agreement.
Council, let's take a short break, then we'll come back. Hello, dear viewer. Welcome back from the short break. We are back again with the two lawyers, constitutional lawyer Tong and Bryan Oboy, who is also an advocate in Juba. We are discussing the issue of the decrees issued by the president for the appointment of officials in the state governments. Welcome back, Tong, and you continue making your point because there was internet interruption.
Yes, yeah. There was a bit of interruption by the network. What I was trying to put across was that people are talking about violations of the agreement. What we should be talking is the violation of the constitution. If you look at the way the president has issued the orders, as you serve the constitutional powers, the mandates given to the governors of the state, and take it to himself. Okay, the law is very clear. The constitution stipulates that the state deputy governors, the advisors, the cabinet ministers, and the rest are to be appointed by the governor and sworn in by the governor himself. Okay. Now the president appointed all these government officials, and then again he delegated the powers to the governors to go and sworn them in. Can you see how ridiculous is this point? Okay, so it is the same mistake they did when they cancelled the 10 states and they created 20 states before amending the constitution, which still holds on the 10 states. Okay, so to me, people should not be talking about the violation of the agreement because the agreement has solely been incorporated into the constitution. What we should be talking is the violation of the constitution itself.
Well, that argument holds water partly, but the downside is that even the constitution right now, as amended, Article 3, Article 5, explicitly says the agreement shall take precedence over the constitution, any national legislation or previous agreement, and in the event that the provision of the constitution or national legislation conflict with the terms of the agreement shall prevail. So the constitution itself even is talking about the agreement. So now why would you say people should not talk about the agreement when the constitution itself continues to talk about the agreement, and even the orders that have been issued, they're also referring to the agreement. So you can see that the issue goes beyond the mere fact that the agreement is left out, but the fact that also the agreement is still recognized inside the constitution.
Okay, the problem with this point is that people, the parties to the conflict, you remember you touched something about the agreement, the comprehensive peace agreement taking precedent over the constitution of the Republic of the Sudan. Okay, when the peace was signed, what the SPLA did was to protect its own political interest, because there was a high level of mistrust between the government and the SPLM SPLA. The SPLM SPLA could not trust 100% the government of Sudan. Agreed now that the high chance of maybe the government of Sudan will not implement the agreement, you know, to the letter and spirit. Now, what they came up with was to put this into the constitution to protect their own interests. Now, when you come to the issue of South Sudan, okay, they have copied and pasted the same scenario, okay? The SPLM in government and the SPLM, SPLA-IO, okay, have the same mistrust. And for the SPLM-IO to protect its own political interest, they have to hold on this issue that, you know, the provisions of the agreement must take precedence over the constitution. Okay? This in constitutional jurisprudence, it does not exist. Okay? There's no any agreement that prevails over the constitution.
Let's hear from you, Councillor Bryan. And this is something also people of South Sudan and those who monitor the affairs of the country would like to know. What is this issue that all the time there is deviation or complaints about laws being violated, or sometimes even laws are not clear? There have been always been these complaints, and we've seen in the beginning, especially in the past few years, there used to be reports about laws being enacted in the parliament, but then they disappear or get altered in between, from the parliament to the office of the president, getting the assent. Then you find some parts of the laws. There have been reports on issues of alterations, and there have been those issues of lack of transparency and making laws public, because one major issue about lawmaking is promulgating the law and making it public. So there has been that issue of secrecy and all this. As lawyers, what would you tell the public, because this problem has been going on for some time, violations of laws and then lack of public access to laws of the country?
Well, first thing we have to understand is that laws are supposed to be public documents. Those laws are supposed to be enacted in a very transparent manner, such that citizens are actually supposed to be part of it, insofar as transparency is concerned, their views. And it's not unfortunate that in South Sudan we find that laws, it's very unfortunate that there is really not so much transparency in the lawmaking process. That's where you find laws being altered, mysteriously. And in fact, that is, if you look at the amendment of 2020 of the Constitution, there was a point whereby SPLM-IO were complaining that some provisions were actually deleted, some were modified, altered, because the amendment that was actually provided to the Minister of Justice by the National Constitutional Amendment Committee was not the same with the one that was actually passed by the National Legislative Assembly and the one that is assented by the President. In terms of its text, they are saying that there were certain provisions that were altered. Out of 124 articles, they're saying about 6 were either deleted, modified, or altered. There was a letter previously that was written by IO complaining about that to JEMEC, and JEMEC actually wrote to the President, and there was a promise that that would be rectified. But apparently nothing has happened. So we can see this is just an example of how sometimes, you know, the law-making process is not followed as it is supposed to be. It's very unfortunate. That's all I can say.
With regards to availability of laws or access to laws of the country, you know, in democratic countries, in several countries actually across the world, you find not even any more people going to get hard copies and all this, but laws are published on the websites of institutions concerned, and people access them so quick and easily. You as lawyers, what would you say with regards to you seeking even legislation or some other laws that have been enacted by the country? Have you been able to get them easily as you should have been, or the issues to do with lack of access to laws?
It's quite challenging even for some of us lawyers to access certain laws. It could be probably because, for instance, in South Sudan we do not have a government gazette, body that is provided under the law to deal with all issues of legislation. Because in other countries there's always the gazette. If there's a bill that is presented in Parliament, it's published in the gazette. When it becomes law, the President has sent bills, it's also presented, or you can access it at the gazette. But in South Sudan, we do not have such a body, although the law provides for it. Most times you have to go to the Ministry of Justice to access some of these laws. But it is still very difficult, even for us lawyers. You go there and you find that they'll tell you they have no idea where these laws are. Previously, the Ministry of Justice had a printer until I think 2014. They used to print most of these laws. You can just apply and they will give you copies. You just have to say the reason why. See, you have to give a reason why you need those laws. And for us lawyers, it's a bit easy. But they used to refuse even for other citizens. If you're not a lawyer, they'll tell you, no, we cannot give you these laws. So you see, that is how difficult accessibility to laws in South Sudan.
Well, yeah, with regards to the Gazette, yes, there's this act which I was told. I understand that there's a department within the Ministry of Justice that's responsible for one of the acts for the establishment of the ministry. Yes, with regards to that. And yes, with that also comes the issue that the ministry,
I think it was
political.
I think it's called Directorate of Legislation.
Yeah,
there's a Directorate of Legislation that is responsible for all legislation, bills, acts of parliament. But you find that even there, they still do not have some of these laws. You know, like especially recent laws that are passed by parliament, it's supposed to be sent back to the Ministry of Justice. But somehow they will tell you they don't have it, and you wonder where those go to.
And because having a gazette ought to be a little bit detached, or even more so detached from politics, and given that the directorate is within the ministry, you're able to see an element of interference or political interference or conflict of interest, because given that there is the directorate is under the ministry, and the ministry is an executive arm of the government, one of the arms of the government. So you could see that there's a need to have a gazette that is completely professional.
I've not heard, or I do not believe that there might actually be some interferences, but I think it's mostly a question of resources and resources and also the will of the government, you know, because things are just being done, you know. One thing I know is that the Minister of Justice, they claim to not have some of the resources, because if they have these resources, then they don't see, or we don't see a reason as to why this law should not be made accessible to the public. But because I don't think it's interference as such, because these are laws that are passed by the National Legislative Assembly, and if the president assents to it, I don't see where the interference will come from. But ultimately, I think it's a question of resources. If the ministry has resources, then they will make it available to the people. Apart from resources, I think also the will.
Political will.
And yes, political will.
Because
from
actually, the right of access to information act, those public institutions, they had obligations to make information available for the public. Yet, when they don't do that under the pretext or the justification that there are no resources, then also this goes beyond the mere fact of that, but also justifying that.
Exactly.
So, welcome back,
yes, exactly.
And we would like, we were talking about why there has been always this issue of conflict within the laws of South Sudan, accusations or allegations of deviation from the laws, issue decrees that could be unconstitutional or complaints all the time. What, in your opinion, is the reason that we have all this all the time, not like in other places where most of the time there are no such complaints and laws or decrees are issued or things like that easily?
Okay, Roger, thank you for welcoming me back again. I have been disturbed by this network here. You know, this is another challenge we have in South Sudan. Well, there are two problems. One is the people who are tasked with this role are the ones that are not well versed, okay, in the drafting, okay, of any constitutional order or a presidential order that is based on the parameters of the law. That is one aspect. If okay, for instance, there is legal administration in the office of the president, and we have been seeing these, you know, errors time and again. Being many presidential orders or decrees citing wrong articles or wrong sections of the law. These are the people who are tasked with this law. They are lawyers, okay? I don't know. I still assume that they are lawyers because the legal administration is staffed by lawyers. You know, you don't bring in somebody who have studied agriculture and you put it in legal administration. I don't think it can work. Okay, so we assume that the problem is with the people who are tasked with their role to do. They are not well versed in constitutional law, for that matter. They are not well versed in administrative law. Do you know why constitutional law and administrative law are always put in one book? These two laws are not separate. Okay, you have to bring in somebody who is well versed in constitutional law, in administrative law, in criminal law, in public international law to be able to do this job. That's one problem. The second is the implementation. Okay, there is always a problem of implementing the laws in South Sudan. We have very good laws, very, very, very good ones, compared to any other country in the world. But when it comes to implementation of this law, it remains on the paper.
Any other country or many other countries? Eh? Any other country or some other countries or many other countries? Not any. Like really?
Many other countries. We have very good laws, by the way, Roger. If I tell you this, but our problem number one is how to implement these laws. Okay, it's how to implement these laws. So these are the only two problems that are associated with the why there are all these mistakes, all these problems subsisting most of the time. Now, let me take you back to the reason. You know, I came late. I caught you up discussing the issue of access to, you know, to some laws.
Yes.
You know, there is a problem in the Ministry of Justice. Okay? The moment the law has been passed by the National Assembly and assented to by the President, it becomes a public domain. Okay? It becomes, you know, a public property. There's no point you can hide a law that has been assented to by the president. Okay? Now, the other issue is that these laws, when you go to the Ministry of Justice and you demand to be given copies of these laws, they will tell you we don't have the copies. They are finished. They are finished. They are finished. Every time they are finished. And they are not the one printing these laws. They are being printed by UNDP. Okay? The moment these laws are finished, they should write to the UNDP, okay, who has pledged to be supporting the ministry or the government for that matter, to produce more copies and bring them. Okay? Now, the procedure used to be that, especially for us, the practicing advocates, okay, if you want some copies, you write a letter, okay, to the office, and then they will go and give you. But when any other common man or any individual who is not a lawyer, okay, comes and demand that he or she be given a copy, they refuse. They don't give them. Okay, they will refuse. They don't give them, which is wrong. Okay,
it's wrong.
Every South Sudanese has a right to be given a copy of any law that has been in. Decline or you refuse to provide them some of these laws. What are you doing? You are denying them their right of access to information, access to have, the knowledge of about their duties, about their rights, about which conduct is deemed criminal, that you should not engage, into committing such kind of conduct. This is the problem we have in South Sudan. And for us to be able to address this issue is to make sure that we put the right people in the right places.
Just to add something, you did your LLM, your master's in law in Kenya. You know very well this complaint that the Ministry of Justice in Juba, they have not printed the copies of the laws and all this. For the current moment in this 21st century, this is all because people access most of the laws, even in many countries now online. You find the relevant institution, put them online, and people download them easily. So why is the ministry, or why are you not people pushing the ministry to establish a website that should contain all these laws as actually even the right of access to information?
You see, my brother, to be very frank with you, there is a very serious problem in the Ministry of Justice. Okay? I agree with you. I did my LLM, okay, in Kenya, and I have been exposed, okay, to how issues are done in Kenya. I agree with you. In Kenya, Uganda, or Tanzania, or Rwanda, or Burundi, or any other African country, most of the laws enacted are online. Every institution of government has its own website. If you go, you log in, you get any information available, any information you want. But when you come to the Ministry of Justice and Constitutional Affairs of the Republic of South Sudan, my friend, is a laughing stock. Okay? The website is there, it has been developed, but it's dormant. It's not functioning. The laws are not uploaded. If you go there, you trail the website, you find everything is put there, but when you click on any information you want, it is empty. You don't get anything from there. Okay? So the problem is, you really don't understand what is wrong. People are still analog in South Sudan in the 21st century. Okay? Instead of us going always to demand hard copies of these laws, they should, ask the UNDP or any other agency that is helping the Ministry of Justice, okay, to empower this website. Download all these laws online. Whoever that is in need of the law should be directed to go to the website, download it, print it, and then you read it yourself. But this is not the case here. When you go there, they will tell you, oh, my friend, we have run out of these copies, and the UNDP has not printed more copies for us. And they have not even informed UNDP that they have run out of these copies. Okay, but how long are they always relying on the UNDP to print for them? They should, the only durable solution is for them to develop these website, make it functional, let it be operating most of the time 24/7. Let everybody go to the website, download any law he or she wants. Okay? And then now you are free yourself from being, bumped into the office every day and asked to produce some copies for the citizen. They are denying our rights. Okay? They are denying our rights directly.
Well, as we head towards the end of the program, I would like both of you to make your last arguments on the issue of the decrees of the president for the formation of appointing those state officials. Nonetheless, we also give you one more chance to talk about the order recently issued by the chairperson of the COVID-19 pandemic committee, chairman of the COVID-19 pandemic, Vice President Abdelbagi Iyakol, and whereby they issued they mentioned some fines for violation of the measures against COVID-19. So I would like to talk about the validity of those orders, but before that, make your final conclusions on the issue of the president's decrees.
Is that to me or to Bryan?
Bryan, start. Bryan, you can start. Just 1 minute or 1.5 minutes.
Okay.
My last say on the presidential decrees for the appointment of state government officials is that that decree or the decrees were made in ignorance of certain provisions of the Constitution. The Constitution is very clear as to who has the power to appoint those officials. Although the process that led to the appointment was proper, because the agreement provides for how these appointments are supposed to be carried out. Parties are supposed to nominate their members, and the list goes to the appointing authority. Of course, the president has a say. The first vice president has a say in those appointments, because the law says that the governors appoint in consultation with the president and the vice president. So I think although the process leading to the appointments were followed, the appointments itself was actually unconstitutional insofar as they failed to follow the provision of Article 165 as to who appoints these state government officials.
Mr. Tong?
Yes, I would.
Yes, hello. Go on.
The appointments were done.
Can you start again?
Ignoring some substantive provisions of the Constitution. That is correct. I would also add that
your audio keeps going.
The right procedure to have been followed was for the stakeholders, the parties, to make their nominations, forward the list to the respective stakeholders, who would then submit them to the president. The president verify the lists and confirm from the other stakeholders or the parties to the agreement whether these lists, okay, are the genuine ones, and these are actually the persons that have been nominated by respective parties. And then after having verified the list, then the president should have forwarded the lists of various state, advisors, cabinet ministers, chairperson, and commissioner to the respective governors concerned. Okay, to go and now appoint them. This is the right procedure. Okay, but it is defective, as I said, in the sense that the president received the lists and he went on and issued the decree. Okay, This is a usurpation of the constitutional mandate of the governor of any states of South Sudan, okay? Now, this has been done. It has already been a serious constitutional mistake. It has gone down in the corridor of constitutional jurisprudence. And what the president should do, okay, is to make sure that the implications that are about to arise, given the fact that the deputy governors, the cabinet ministers, the co-chairperson of commission and the commissioners have been appointed by him. Already there is going to be a political conflict. Everybody would say that, look, I've been appointed by the president. You don't have the power to remove me from my office. You see this? This is one of the serious implications of this. And of course, the governor has been disarmed. Constitutionally speaking, the governor has been disarmed. He doesn't have the power to remove any state official here, be it the minister or commissioner or even the deputy. Okay, which in that procedure should be done through consultation. If a deputy governor is to be removed, then the consultation to be done, and then the nominating party, okay, have to submit the list replacing the outgoing.
Well, there's a network issue, but we got your point. Now let's conclude with the order from the COVID-19 National Task Force on COVID-19 pandemic on the issue of fines for violation and all these penalties. What do you say about the validity of those orders?
Who is that question addressed to? Oh, yeah.
Yeah, to you, because we've lost Tong, but he's going to get back. So we try to, because there's a penalty. People even fined and all this. Do you see it as valid?
Well,
in legal force.
Okay. Before I go into that, before I answer that question, I just want to say something about the decree, which I have not touched on. So if you look at the decrees, there's that the president, the decree quoted Annexure D, the implementation metrics to access. Now, and people are arguing that that law or that provision is the one that gave the president the power to appoint the state government officials. If you look at item 20 and 21 of Annexure D, it talks about, it provides actually for activities to be performed by the parties, activities to be carried out under access, who are supposed to be responsible for those, for carrying out those activities. Those people who argue that the president had powers to appoint those government officials, the state government officials, base their arguments on Annexure D, the implementation metrics to access. But if you look at Annexure D, items 20 and 21 that they say give the president the power, 20 says the constitution of the state government and the person responsible, the presidency, and the parties. Yes, item 20. Then item 21 says, for appointment of state government officials, the persons responsible, the parties, presidency, and RGM. Now, I think the people who are arguing that gives the president the power is actually a misplaced argument, because when you see the word presidency, it's not the same thing as the president. And I believe that the purpose of that provision is actually to ensure that the parties stick to the provision of access insofar as how state government officials are to be appointed. Ultimately, Article 165 of the Constitution as amended is the one that prevails. it is clear. So there is really no argument as to who has the appointing authority.
Yeah, the provision of
having said that,
165 is explicit. 165 sabbatical 6.
Yeah. Okay. So having said that, with regard to the order, the order by the chairperson of the task force on COVID-19. Well, first and foremost, I do not know under what laws or what mandate this COVID task force to make those orders. The Constitution is very clear as to how laws are supposed to be made. Indeed, one basic principle of criminal law is that there is no crime unless it is written.
No crime is written.
Sorry?
What says no crime is alleged? None is a crime without a law.
Yes, exactly. They're saying that the Constitution says that you cannot be charged of an offense unless it is written or it is provided under the law. Now, the question is whether the order is actually law itself. I believe it is not. I don't think the COVID task force, for instance, has the power to make those kind of laws, because our Constitution gives the mandate to make laws to Parliament. Now, it's only Parliament who can delegate its powers, but even the delegation has to be within the confines of the law. You don't just delegate, you don't give a blanket delegation that you can make any orders that have the effect of law. And I don't think Parliament actually gave the task force the mandate to make such kind of directives. We understand that we are in a pandemic, and if you look at perhaps the Constitution gives the President the powers to make laws during emergencies. The question is whether that order or the directives by the task force is based on that. Whether it is because of the emergency that they are given the power to make those orders. Because the President has the powers to make directives, orders during a state of emergency. And the President can delegate that. But there are also limitations. Powers under emergencies are not supposed to be exercised, for any duration of time. It is only for a period of 30 days. And then if Parliament ratifies it, or if Parliament rejects it, then we go back to the status quo. So I think maybe we
got you. Let's hear from Tong, because we have 1 minute left. Exactly 1 minute. Tong, you welcome back. We're glad that you're back. You conclude for us with that in that 1 minute.
Okay, thank you. I was trying to say that what we have to do is to strictly observe the principles of constitutionalism, because anything that is done has to be done within the parameters of the Constitution. You know, there is always a common saying that nobody is above the law, even the President himself. Okay, the powers of that or other institutions of government. Okay, you know, the Constitution is very clear, and even the agreement is very clear. So there's no way the President has to appoint the deputy governors, the cabinet ministers, the chairperson of commissions, and the commissioners. How would you ensure the working relationship of these levels of government in the state? Somebody appointed by the President, and and is supposed to be accountable to the governor. Now, how will you be, holding this kind of an official at the state level or the county level, okay, to be accountable? Is he going directly to be accountable to the President, which is again the principles of the Constitution? Or is he going to be accountable to the governor, who of course was not the appointing authority, and which the Constitution says, the governor should appoint, the deputy governor, the state cabinet ministers, the chairpersons or heads of commissions, the commissioners of various counties of, designated state. So we have to actually be cautious in, making decisions and that are outside the parameters of the Constitution. We have to hold on to the agreement, of course, because it protects the various interests of the political parties to the agreement, but not to the point that the agreement should always override, the provisions of the Constitution. Yes, there is always a level of mistrust that always exists between the parties to the agreement. But once the agreement has been incorporated into the Constitution, definitely it becomes part of the Constitution. And the Constitution is, in this situation, the fundamental law of the country. It is the law of the land. It is the supreme law. And any piece of legislation that is inconsistent or does not conform to the Constitution must be struck down as to the inconsistency of that piece of legislation or law. So we really don't know what is happening around the president, the advisors of the president, the people around the president, the legal administration in the office of the president have to, understand the implications of the issues when they don't correctly advise the president to do the right thing, which falls within the ambit of the law. Okay. Now, the president has to be prepared to address any challenge that may arise, which is the result, okay, of his constitutional mistake he has committed by appointing the state governments, okay, and again asks or delegate the powers to the governors to go and swear the name. How can you sworn in somebody you did not appoint? Okay, you should be the one now to sworn in all these kind of deputy governors or cabinet ministers of the states and commissioners and chairperson of the commission and their members, not the governors again to go and sworn them in when the governor did not actually appoint them.
Thank you very much, Council Tong. With that, we've come to the end of the program. We were having two lawyers. One, Tong Kuocnin, he is a constitutional law specialist and advocate of the Nile Advocates and Associates, and also Bryan Oboy, Itorong, managing partner Oboy and co-advocates. Thank you very much for being on the program.